Everybody's out here doing this really good Second Amendment work, fighting the fight, and the Supreme Court's like, I don't know. And they're not helping at all. We're the arms attorneys. Today we're talking about a case that has just recently come out on the ATF's rule on 80% lowers, frames, and receivers. This is something that's flown under the radar for a couple months here, but we've just had a new injunction drop. We're going to talk about it. Stick around. We're going to talk about who's affected, what you can and can't do in purchasing your 80% lowers right now, some novel arguments to come out of the Second Amendment Foundation, and where we think this is going forward. But before we get started, show your support for the Second Amendment by hitting the like button.
And a special ask for this video, we're going to ask you to enable notifications. YouTube's been monkeying around with notifying folks when a new video is published, showing it up on their feed. So that goes a long way in helping the channel, and we would really appreciate it. We don't normally ask that stuff, but YouTube is kind of playing around with us. But let's kick things off. We're talking about homemade firearms, essentially. And so this has been a long tradition in the American history. Everyone has had a right to build their own guns if they want to. And what we saw come out of the ATF last year is a final rule on what they called frames and receivers. Now, who's affected by this rule?
Well, it's the manufacturers, really, because anyone, if you had purchased one before the rule went into effect, that's okay, right? But just going forward, the manufacturers are not going to be able to sell you what was at that point known as an 80% receiver. Why? Well, there was no real reason for the 80% rule, right? We actually did a lot of research into this. What did you find?
I found about 45 years of ATF history of treating these incomplete firearms as just material parts that
not yet firearms.
Yeah, not yet firearms. And so it looks like they kind of flip-flopped there.
But the scary thing about the flip-flop, I thought, is there was no rhyme or reason for the 80% number to begin with. And so then when they flip-flopped, I thought, well, I mean, they changed their mind on something they made up out of thin air. What's the law say about that, right?
No, exactly right. And so to a little bit more context, what we see is these incomplete or 80% kits, or you'll hear leftist politicians call them ghost guns. These are just incomplete firearms kits, accessory kits. What folks would do and hobbyists would do is they would pick up these kits. It did not require a background check when purchasing it online. You could actually have it delivered straight to your house, or you could go pick it up off the shelf at your local gun store, and you wouldn't have to fill out a 4473, and then you would get to engage in the hobby, build your own gun, customize it however you want. Now, a question I got from a lot of people when this rule initially went into effect was, hey, I bought one of these kits. I haven't built a firearm yet. What am I supposed to do? What do we say to those people?
Do it. Build it.
Yeah, that's exactly right.
That's your right.
So this rule really only affected manufacturers and gun dealers, essentially, because what the ATF did is they're saying, hey, these aren't incomplete kits. We are going to treat these as completed firearms. So therefore, you would have to go through the background check process. You couldn't have it delivered to your house. You'd have to go through a gun dealer. You'd have to fill out a 4473. You could still build a gun, but we're also calling it a gun, so...
Right, we're changing the definition of firearm, right?
Exactly right.
Which is, sounds a lot like lawmaking to me.
Yep. Yeah, it does. And so enter this lawsuit. We have a handful of these kit manufacturers sue the Merrick Garland and the ATF saying, hey, we're going to be irreparably harmed by this thing, and you can't do this.
You can't do this, right? And this is just for anyone who's curious. It's out of the Northern District of Texas, Fort Worth Division. Thank you again, Texas. We have Vanderstock et al., Blackhawk Manufacturing et al., v. Merrick Garland et al., and it's action number 422CV00691-0. So if you care to look it up, there's a lot there, and it is very interesting. But we have just had another injunction in a series of injunctions be granted, and I think this is the most interesting of all. So what's going on with this one?
Yeah, so now we have Defense Distributed entering the lawsuit, and essentially they're saying, hey, look, we're going to be irreparably harmed by this rule. This is going to drive us out of business, and they're asking the court for relief, essentially holding back the federal government from imposing this rule on them so that they can continue to engage in business. Now, the court goes through this kind of this process of determining whether an injunction should be granted, and ultimately, what do they decide?
They decide that the injunction should be granted as to Defense Distributed. So now we have 3 manufacturers who are allowed to continue manufacturing and selling their 80% receivers. It's Defense Distributed, it's Tactical Machining, and it is Blackhawk. What's interesting, though, about this injunction is there was another party that asked for an injunction. And do you want to talk about what happened there, Richard?
Yeah. So our next, person to enter the scene, new player enters, is the Second Amendment Foundation. And essentially, they were arguing on behalf of their members, saying, hey, look, all of our members, our consumers, are damaged by the implementation of the frames and receivers rule, and they were asking for relief as well. Now, rewind just a little bit. Remember when we just talked about this? This primarily affected gun makers and our gun stores, people who are selling firearms. Now, this is a little bit of a different approach from the Second Amendment Foundation, saying the individual consumer would be affected, where I don't know that the rule affects them that much. And what does the court say?
So the court says the consumer isn't affected, essentially. And I thought the Second Amendment Foundation's argument was interesting because they essentially say, look, they, like all of these human beings out there, our Second Amendment Foundation members, think that they can't purchase these 80% kits because this rule went into effect. And so it affects them and they're irreparably harmed. And the court said, actually, no, because they can purchase them. The rule didn't really affect them in the first place. It really was directed towards the manufacturers and distributors. So all of your members, they can buy from Tactical Machining. They can buy from Blackhawk. They can buy from Defense Distributed. And so they are not irreparably harmed. I am not going to grant this part of the injunction. And, realistically, we don't need him to, right? We don't need this judge to.
No, because we have, avenues for these people to engage in the hobby without having to go through this,
They're not going to be prosecuted, right?
No,
They're not going to be prosecuted for buying a kit, for owning a kit, for having a kit. So yeah, I get it. I mean, look, I love to see like the federal government have it handed to them in every way possible. And whenever you see an injunction denied in part, you think, oh, but really, it really wasn't necessary here. So, Richard, what happens next? So let's say this is a preliminary injunction. We know what's going to happen, right?
So we're going to see an appeal for the preliminary injunction, and we're going to ask, the ATF, Merrick Garland, they're going to ask to stay this injunction pending appeal to the Fifth Circuit Appeals. I'm hopeful about that, though.
Oh, yeah. Well, I'm hopeful for the whole process now, because, I would say before 2022, the Supreme Court was like, the Supreme Court was like that guy in the group project who doesn't do any work. Right? So it's like everybody's out here doing this really good Second Amendment work, fighting the fight. And the Supreme Court's like, I don't know. And they're not helping at all, but they have finally helped us. And I think are on track to continue to do so. So we're sitting pretty on this stuff. The ATF is learning its lessons the hard way.
Yeah. And I would say, and this is an important note, that I think is getting overlooked a little bit. We all are, for the most part, hanging our hats on the New York State Rifle and Pistol Association v. Bruin case about, hey, looking at infringements of the Second Amendment, violations of the Second Amendment. In this frames and receivers rule, though, I don't think they even have to bring that in.
No, it does not appear that that's the basis of the court's reasoning, which is interesting. It's a great case. It's great reasoning, but it's also nice to see, a judge sort of agree with our reasoning before that case dropped, because you can't do this. This is agency overreach.
Right.
You cannot legislate from your regulatory state. You can't.
No. So we see the folks who are affected by this, manufacturers, dealers. We don't see consumers affected that much, but I do think that this is a good argument going forward that the Second Amendment Foundation put forward about this chilling effect, because we see this stuff in like third world countries where we have laws getting passed and repealed or arbitrarily enforced, and this chilling effect that it has. I think that's a pretty good argument going forward, talking about the chilling effect on a fundamental right to keep and bear arms, with just kind of the regulatory confusion.
100%. If it's illegal today, illegal tomorrow, legal again today, most law-abiding people are going to say, I don't know if I can even touch it because I do not want to break the law. That's 99% of gun owners.
Right. We
do not want to break the law. And so it is chilling. And it's a great argument, and the court didn't buy it, which is fine. I understand the court's reasoning. But it is, I think it's a fascinating one going forward for different issues.
Yeah, and I'm interested to see what folks have to say about this. Do you think that the federal government is causing a chilling effect on the Second Amendment by engaging in this kind of regulatory I don't know, hoopla. I don't know a better term for it.
You're monkeying around with the
law.
register.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please comment for us below, enable your notifications, and until next time, we're the Arms Attorneys.